Okay, good morning and welcome to Monos. Featuring me, Monica Mo Justice. All right, I was just trying to get a gauge of how long is the delay. I just smell, I just smell. Featuring me. All right, it's a significant little delay there. Okay. Hey. Oh, yeah, I think we've settled. Yeah, it's settled. Okay. Um, I hate this one little thing that I have to do in the morning. Ah, let me go back. I need to do this. Well, actually, no, I could do this. All right, today's discussion will be focused on um the professional protesters case. So as you may or may not know, there is a little trial going on in Kenosha, Wisconsin, involving a double homicide and attempted murder of three people who were attending um, or participating in who knows um, the protests that erupted in August 2020 following the police shooting, a police involved shooting of an African American male who was walking back to his car, and we saw him shot in the back at at point. One of the most egregious things that I heard yesterday in the closing arguments was when the defense attorney alluded to that incident and basically just um, gave his endorsement of the police officer doing that because there was no charges brought against the police officer. It is it is terrible when you're looking at these court cases and you're seeing the bias of the attorneys involved. But that's the world we live in. What is that dude's channel? Ooh. Okay, so here we go. um, as you know, I was live yesterday afternoon, and I decided that the best thing for me to do with this, with listening to these opening and with these closing arguments, was to view them. Um, Let me see how to say this. To view them after the fact, um, so that I could enhance the speed on them and not be screaming at the screen as I listen to the judge interrupt and stuff. It just has gotten too much for me, so I couldn't take it anymore. Okay, so here's what had happened. One of the most disturbing things yesterday was that the judge removed the sixth count, which count number 6, which was for the um, possession of a dangerous weapon by a person under 18. And the reason why he said he removed that language was because the law was not clear. I think he said ambiguous. So let me all right, this is good. Okay, that's that. All right, so here's the closing argument. I really took notes for the defense's case because I was just like, ugh. I couldn't be so. I understood what the prosecutor's closing arguments would be, which is basically this man killed these people, and although these people they wanted to paint a picture of the people being not the best citizens that we can have, and want to paint a picture that Rittenhouse's life was more valuable than another's. It was just a quintessential look at the right to carry guns and the right to defense, self-defense. And I appreciated at the end of the prosecutor's case, they really zeroed down that if everyone has a right to self-defense, what makes one person's right to self-defense more important than the other? And I thought it was clever of the prosecutors to wait till they were in the argument phase to present the argument of the protesters. Because remember, there were protesters. These are professional protesters, obviously, because people understood that they needed to have paramedics. They needed to have, all of these resources available during a protest, stuff I never thought you would even need. And he turned around and he said, no, this is more or less an active shooter case. Good morning, Brandon. Good morning, Gleb. This is more or less an active shooter case. And you have to put your mindset, and this all happened quickly. And this is what's important. Even though we're going frame by frame to show you what happened in terms of where one was positioned, where the gun was positioned, where the people were positioned. You have to also, good morning, Karen, take into account that all of this stuff happened within seconds. And it's a live engagement. And what is live? An active shooter. If you got somebody running through there shooting somebody, he's running with this gun out. And people are saying, he's the person that just did it. You've got good, I'm not going to call them good Samaritans. Good morning, Rio. You've got people that would want to tackle down an active shooter. And I never thought about it. If you guys have jobs or careers or any kind of company that when we traditionally went into the office, you would have embarked in a new requirement called the active shooter training. And in the active shooter training, they tell you either hide, or protect, or you either hide in an active shooter. You got three choices in an active shooter activity in the office. You can either hide if you can't escape. So you need to try to get the hell out of there as soon as possible when they give it. But if you do not get out of the building, then the next thing you need to do is to hide. And if you're unable to hide, then you're going to have to fight with all your life, right? And it never dawned on me during the active shooter training to be like, well, what's going to be the consequence if I kill this mofo? Because the consequence is going to be like, it was self-defense because this person had a gun and was actively shooting people. So they pull this off in the arguments because I think they would have had a hell of a hard time pulling this off in their case in chief, because the people got on there who could have been victims, right? These witnesses who all could have been shot accidentally, you know, as this guy was running around shooting people. And they want to take the position of, no, I wasn't in fear of my life. He had to do what he had to do. That is a bunch of malarkey. Prosecutor did a good thing. So he uses that active shooter reference, and it pisses the defense team off because it gives a clear picture that or it paints a picture. I don't know if it's clear for these jurors or not, but it paints a picture that if you were out there and you heard gunshot and you hear people saying, he just shot a man, he just shot a man, and he's running down the street with the gun, that there might be somebody in the crowd that might want to stop this man who just shot somebody. And their goal is to tackle and bring him down. These people that was running after him didn't have a gun, with the exception of the one who lives, the one survivor. The first dude used his body, just jumped over him. We believe it was a tactic, a military tactic, or some kind of professional training that had Kyle go to the ground and come up shooting like it's just seriously crazy. And he was rolling around and stuff, and he want us to believe that he was rolling around because he had just got knocked out, but he had enough wherewithal, right? There's somebody that is telling you that somebody kicked him in the damn head and he was trying to come to his but you was still able to shoot people clear. Negro, you was on that ground, post up, and you was catching them. Pow! Pow! Yo, that shit was just crazy in that amount of time, right? If this was a action movie, he would definitely get an award for it, because it was full of suspense. It was full of everything that you would want to see in your, what's the movie with Bad Boys? It's all the kind of shootout you would want to see, right? Happening right then. Even down to the people's responses that were in the crowd. They scattered at the right time, et cetera, et cetera. Anyway, I thought that was genius to make a connection to the fact that he was perceived by the crowd as being an active shooter, and that there was really no time to fact check things in the heat of that moment. So that's it. Good morning, to Blessed to Be Stressed. So let's go. I went to the end of the case because I thought that was important first. That's because all this other stuff had me like, that's it. I appreciated that the prosecutor pointed out that yes, we brought Sal and Sam, the owners of the car dealership. So they call it Car Source, the owner of Car Source 1, 2, and 3, right, to the stand. Now he said, we don't really care if they lied on the stand. That's for you to determine why they lied. That's what being a juror is all about. You get to look at the evidence, and I thought that was a good point to put out. jurors, when you serve as a juror, you are the determiner of facts. You determine which facts you're willing to accept. So you can look at these guys' testimony as being one of two ways. From the prosecutor's perspective, these were intimidated men who allowed their facility to just be taken over by this militia, these professional protesters or these professional military people who come to the protest to prevent the rioters from going wild. Because there's a component of this protest where there are people who are protesting. Then there's a point when the protest gets inundated and overwhelmed with these people that come to riot. They come to destroy, tear down, and everything and make it horrible to live in, right? See, in Watts and in our previous protests that were Black men's, right? They were Black people issues, African American people issues, right? Black issues. As they burnt the shit down. Watts, Rodney King, they burnt the stuff down. When you go into Minneapolis, Minnesota. When you go into the Minnesota, it's the first time you're really seeing this professional protester / rioter who comes in with the goal to burn it down. When we look at the case in Georgia, the one with Brooks, we see again protesters, but these were just angry Black people, and they burnt down Wendy's, right? They burnt down that whole thing, right? They might not have been, but that's not really true, because it seemed like professional protesters came in and they did the damage. I'm calling them this how I'm dubbing them, professional protesters / rioters, because at some point you couldn't tell a protester from a rioter. Hey, Amber. So I want to thank all of y'all for dropping in this morning, actually. So from the prosecutor's perspective, the owners of the car source may have lied on the stand, but what were their motives to lie? According to the defense, it was to protect themselves from being sued, right? But if you listen to the prosecutor's case, it sounds like intimidation, and I took it as intimidation. And if I was a 13th juror, I would have definitely took it as intimidation. I don't give a damn if they was standing there taking pictures with these guys. Some of these guys worked for them once upon a time. They may have come in and said, listen, we're going to stand here and stand our ground. Can we stand here? Right? Any of those things could have happened. Nobody probably thought that they was going to get buck wild crazy and have this vigilante dude on their team. He was, check out Rittenhouse. He's supposed to, in one evening, one man with no high school formal diploma, right? 17-year-old. He currently has a were they professional protesters? You know what? Actually, Rio, I may have to agree with you, because I'm gonna go back to a book that we need to come back and read. It just had so many of the other stuff inside of it. I couldn't really brace it down. In Ferguson, I read a book written by a young man that I'm gonna come back and introduce out here as a book for the book club again, where he's walking us through his professional protest training and stuff. It's really detailed inside the book, what they go through. I didn't even know this. I didn't know any of the tactics or what have you, but he did. For these men that owned the store, they were really, I just feel like they were the starting point, or they were the place these people camped out at. But I think the prosecutor made an extremely important point. If they had authority by the owners to be on the property. And they heard that the police were on their way after one of their men shot and killed people in the street. They would have stood their ground. But instead, they all left. They fled. Even the old Edith Bunker woman that came and testified on his behalf, even she fled. Law-abiding citizens don't flee the police unless they are African Americans, because we are in fear for our lives in situations like that, especially if we was armed. Imagine a bunch of Black folks. I just want you guys to just put on your imaginary hats, right? Imagine a bunch of Black folks standing around armed with guns at a facility, and the police are coming to it because one of your men inside there shot somebody on the street. Do you stay or do you get away? They have the same fear we have of law enforcement, even though they be acting like it. Let me go back to Carl's not having any formal, he did not finish high school in a formal, traditional way. He's on here taking that high school course. Hold up. He went to, and y'all know the commercials on television. I wouldn't even wanted to say this, but somebody told him, you need to be a high school graduate, sir. Was it Penn Foster? Penn Foster College, okay? Even with being in Penn Foster College, this is what this dude hats he was wearing that night. And this is somebody who definitely needs more formal training. He was supposed to be an EMS worker, a fireman, and a police officer all in the same evening. How do you say, oh no, I'm not gonna do what that crazy dude do. Yo, I never heard people talk about themselves like, so-and-so, what are you saying? Scary. Okay. Elaborate on that. Defend your position. Why is he considering himself, right? A firefighter, an EMT, and a police officer. And that night, he's walking around with a fire extinguisher, putting out fires, while he's strapped wearing a gun, acting like he's law enforcement, with a fanny pack on to provide EMT help to people, emergency medical technician shit. What a fantasy this young man was living out there on the streets on that evening. He was everything. You know how I hate the song, I'm Every Woman? He was every man he could be that day. EMT, fireman, police officer, crazy. You know what that amounts to? He was invincible. He was everything. Imagine how bold he felt and proud. Look at how he walked through those streets. They better be blessed I'm not juror number 13. You can't be a 13th juror. But just imagine if you was to really look at what he was carrying as his ego. So as he's walking on the interview with the media, so not only is he the fireman, the EMT, the police officer for the evening, he's being interviewed by a news reporter who's following him as he's engaging. Prosecutor makes a good point. The whole night is videotaped. You can go almost to anybody and everybody's camera footage to find moment by moment by moment, every activity. What can't you find? You cannot find the video, not one video, where this man that he killed, Rosenbaum, the first kill of the evening, you cannot find that man threatening him. You only have to go. That's why they had to put. So Carenza Harris That's why they had to put this guy, their client, on the stand, because he had to tell people that he felt threatened by some imaginary conversation that they could not find, or an imaginary threat that nobody could evidence with all the evidence that was available. Crazy. So when we're like, why did they put him up there? He might have wanted to do this. There was nothing to corroborate why he did that. He had to tell people he heard something. I might have to get some water. Yes, sounds like he was having some sort of mania as well. Yes, they do point to his Twitter account where he grandizes his participation in this. Please hold, I gotta get some water. Take a break, y'all. Okay. Oh, let's see if I can get this down. What was in the EMT bag? Okay, according to the testimony, bandages and stuff that was supplied by other people for him. He claims, Rittenhouse claims that he stocked that EMT bag, but his other people that were there at the protest who were witnesses for either the prosecutor or the defense each admitted to supplying him with medical supplies in that bag. I can't believe I skipped the page in the middle of something. All right, so this Penn Foster High School online, to me, is very critical because for me, that stood out when Rittenhouse was describing himself. First thing I said was, this boy didn't finish high school. This is equivalent to a GED. And then he's currently in the Arizona, some other Phoenix. He's in another online school. So I don't understand how somebody who has poor social skills to be educated will have good social skills to be a helper to people. He needs to spend the rest of his time in jail because he could do all of that, or whatever the limit is for killing. I don't know if it's 25 years to life. He needs rehabilitation, in my personal view. That's how I see things. He needs to never be allowed to have an AR anything again in life, or be able to carry until he has matured. He needs maturity. He's not ready for it. And his crying mama in a thing, and I normally don't like to make fun of parents because I know as a parent, we always go for hours, even in the wrong, right? We still, because we're a parent, especially a mother, we still go for hours. Where's his father? How come white America is not asking this single woman, where him daddy? Oh, we understand because him daddy live in Kenosha, and he's allowed to say, I visit to Kenosha a lot because my daddy was here. But instead, he was actually storing his gun in his friend's daddy's house. So, but no one's looking for his daddy. But if this had been a black black defendant who did this, they would be looking for his daddy and his mama and wanting to hold both of them accountable. Her tears is just disgusting to me. Another good point the prosecutor made, before I go to the good points that I think the defense made. Another good point the prosecutor made was that Rittenhouse cried on that stand, but he shed no tears. I didn't even think about this, for the people he injured. He only shed tears for himself, which aligns with my assessment, but I didn't think on the other side of it what he didn't do. Like I was like, those are tears based on his fear of going to jail for life. But there was no tears for those men he killed. Even if you had to kill somebody, let's just suppose that, you might be a little remorseful and say, I wish he wouldn't have put me in this position where I had to do that. You understand? Because I think if you saw it from that point or said it like that, I might say to myself, oh, okay, that's different. I believe he's gonna get off. I believe when they took, so listen, that would make this right. Let me just say this, make this go viral. That would make this all right. Because that's what we're expecting to happen, him to get off. What would make this different is if he doesn't. Now, it's not a cut and dry case. It is, does any, as a juror on that, as a juror, is there reasonable doubt for you? And that's what's going to matter at the end of the day. Is there doubt? Did the prosecutor give you enough information so you don't doubt his motives? That's why I strongly believe bringing you to a position of saying all the people that he shot after the first guy, they weren't a mob chasing him down to get him, as they said. They were chasing him down to get an active shooter who just shot somebody. Unless the mob was there and saw it happen, you can't say this. These were people that were along the way as the man was running. They were coming from another direction. So understand this. They were coming from another direction when Rittenhouse was running this way. And they're hearing the people behind Rittenhouse say, he just killed somebody. Stop that man. That's the point that you have to really pay attention to. These are not the people that were running to get him. These were the people coming this way when Rittenhouse was going that way, who listened to the people that was behind him and they joined in. They were the closest ones to put hands on him at that point. And that's why they put hands on him. You had somebody jumping over him and he fell. Rittenhouse fell. It's just crazy. He fell and did all his super duper maneuvers right out of like Grand Theft Auto. And I am so surprised. Where are those anti-video game people? You know why? Because they're sitting here on the YouTubes and all of these social platforms playing these games in mass production, no longer just inside their homes. And these people are afraid to say anything about that. When we know there was a whole campaign of that. You know, yesterday there was a verdict in the Sandy Hook case that the parents, the victims of the families of the victims of the Sandy Hook came out and won. So these people don't want to be sued, but we all know what the mentality is for some of these people who play these video games all day long and engage in these type of behaviors. All right, so I think I've given you, let me just go through my little notes because I did the defense at the end. of my closing arguments there, because there was really not that many points made by the defense for me. That was beyond what I just told you, even though it's been 30 minutes worth of stuff. I still think the defense did not the defense, the prosecutor did a horrible job prosecuting this case. They had a horrible judge on with them in the process. But I'm just gonna say, I'm gonna quote the prosecutor. Everyone else has the right to defend themselves, not just the defendant. So when you see so the guy who didn't get shot, but they can't identify him jumping over his head, and the yellow pants guy is the black guy, and the black guy said, "How can you be a medic right now when we was just past you down there and you was aiming your guns at us? So you can't want to kill me 1 minute and then provide me with life-saving measures the next." Sorry. And the defense points out that the very man that saved the guy that lives life was one of the people that was down in Rittenhouse's camp. So he did do what he came there to do, but he also, that man was a former military dude. He had a whole different perspective on how he dealt with the protesters or rioters, whichever one you want to call them. Last but not least, this Rosenbaum, the first victim, and I'm going to call him a victim from my perspective. I see him as a victim because he was running after dude. They show him jumping. He did a reaction when a gun was pointed at him. And homie still shot him. And then you see him fall. And then when he fell, he just shot him 3 more times. And one of those times, he shot him in the back. We're not talking about shooting somebody with a gun at point blank range. They say it's 4 feet away. They pulling out measuring tapes yesterday to talk about what 4 feet was. The bottom line is you shot somebody with an AR-15. One shot blew a man's whole bicep off his arm. So imagine what that did when it entered this other man's stomach and the bullet went up into his lungs and his heart and pierced him. Same shit happened down to the other street with the other dude. It only took one, it was one and done. Maybe Rittenhouse didn't understand the totality of what the weapon he had in his hand could do, the damage it could do. But it damn sure did a lot of damage to people. Let me see. I strongly believe that the judge needs to be disbarred. I missed because somebody on YouTube was calling me at the time, talking to me. So I missed when his phone went off with the Trump theme song. Because I would have loved to hear it. And as I go back and play it, I can't even find it in the PBS tapes, but maybe I will go back through PBS to see if I hear the moment the judge is getting the song played. Then I might feel a certain kind of way. But the judge did end his final conversation to the jurors, and he said to them, "It doesn't matter. You're the person that's determining the facts, not the current president and not the former president." So that's much for that. I think the judge had a lot of bias towards First Amendment, Second Amendment issues. And I think that's who he was more afraid of. Not Rittenhouse's right to do what he did. But this Second Amendment, he's sitting here on what could be one of the most controversial cases of our time on Second Amendment right to carry, right to self-defense. But as the prosecutor points out, everybody in this situation can say they all had a right to self-defense. Whose right superseded anybody else's? Rittenhouse, as they point out, was lying every step of the way. Who he was, what his credentials was. When people ask, when I tell you about that shiftment, this man is running this way. This man is running this way towards the gunshot. This man is running from the gunshots and people are screaming, he shot him. He's asking him, what happened? I'm going to the police. I didn't shoot anybody. If you say you didn't shoot anybody and everybody's saying that you shot everybody, what do you think anybody is going to do? I have been ignoring my duties watching this trial. Okay, I don't know what that means, but do your duties, girl. I strongly believe that, okay. Mo, you should have submitted your notes to the prosecutor. I agree, the prosecutor dropped the ball. Yeah, so if you know, Darshell, the other night I was doing this watch party and we got sidetracked in the watch party because we started looking at the Wisconsin law on this this possession of a gun. I would have to do more due diligence because I don't know how it got to be in this other statute they was looking at when there's another statute that they charged him with. So again, I'm New York, New Jersey based thought premises. I can't even begin to look at how other states do their things. All right. Photos of the injuries. So they did show the injuries again to bring the impact of how the people were murdered and what damage and carnage that type of gun could do. And that's very important to me because if you got the most powerful weapon and I just got this rinky dinky handgun, Glock, right? Type, I guess, I don't know what the other guy had as a gun. There's no comparison. There's no winning. There's no winning. And like I said, I believe that Gross Crutz, whatever the hell his name is, I believe he just froze up. He might have had his gun out, but homie definitely froze. All right. So now what are the key points for me, takeaways from the defense's position? One, defense doesn't have the burden to put on a case to prove anything. Question about how do I feel about the gun charge being thrown out? Like I said, I really don't understand how they got from the gun charge he was charged with to the one that they were discussing, to the Hunter's charge they were discussing at the close of their case as they was walking through the charges. So I don't understand that. I don't understand it, but it might be, when people write the laws, they also write the intent. And this is why you have to really pick your voting is so important, and you have to pick your legislative people, not by people you like, but by people who are going to do the business of the people, because that's their job. Their job is to write laws. The legislative, these people that we elect to go to Congress and to go to our council and our city halls and our so on and so forth, their charge is to write laws and make them clear and concise. Most of the time we hire lay people and then they get lobbyists in there and they write laws that cater to all of them that make no sense to us, and they become convoluted and weighed down. And then when you get into a situation like this, you find out that it is not enforceable. When you find out that a law is unenforceable and there's ambiguity in it, this is why you got to the point where the judge had to drop it because it was not clear. Honestly, I would say at this point, it didn't even sound like it was good law to me. He did a motion for a mistrial court of appeals, and the judge made something abundantly clear. That prosecutor on Friday knew that they were having a problem with that charge. Judge said, you guys could have went to the Court of Appeals on count 6. And I said, well, I'll be damned. He said the statute as determined by defense based on the barrel. So the statute that they was referring to refers to it being unlawful to have a gun, have a specific gun based on the barrel size of the shotgun. The gun that he purchased was within those parameters. So whatever other law they was looking at has a provision in it. So here's how laws are written. It is boom, 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 A, B, C, D, right? And if you got A, B, C, D, you might have to meet all of those elements for it to be applicable. And one of the elements that was in that law that they was using was not to have a short barrel or have it sawed off or have the gun manipulated in any way. Because you notice in some of these active shooter cases, right, they have modified the gun. In this particular case, the gun was as purchased. There was no modification to it. So that's what makes it, that law was speaking to this. Oh, shit. Now, somebody want to come in here and tell me it's BS. Where you been? That's the person I needed to hear from. Good morning, Gears. Good morning, Cooking with Steel. About this gun. You looked at the law on Friday or whatever day we was looking at it. I cannot tell you I saw any language in there, and I have to ask Glib because we was looking at it. I don't remember seeing any language about barrel size, but yesterday when the judge threw this out, when he threw out the count where he didn't let it move forward, he said that there was a short barrel. This prosecutor took no efforts to do that. At least in the case of George Floyd, that prosecutor had no problem going to their appeals court to overturn a judge in the middle of the case. They're not doing that. And the reason why I think they're not doing it is because the prosecutor did what prosecutors can do. And this is what has some of these communities so upset, the white community so upset. He exercised the right to prosecute other people there. Some people he charged them and then compelled their testimony, and they probably will get more lenient sentences. Other people he charged them, and rather not have them come into court and do what, folks? Plead the fifth. They let it, they didn't do it. Neither side brought in what could have been potential witnesses that the prosecutor has indicted because they didn't want to have a case where the people plead the fifth. I don't see how the barrel length is relevant, especially for someone who can't possess it. So what they're saying is that whatever parts of the law, and you know what, after this, I'm gonna pull that one up because we could not figure out, I went based on the numbers they had the other day, what it was. They were looking at anybody. want to look, you know, I gotta go log in for work in a second or two. What numbers was it? It was not, it was like 29 something. I wrote them down. Oh, wait, I have two places. Damn it. Now y'all all want to come through. It's like y'all just woke up. I've been here all morning. What are y'all doing? Hold on, I'll tell y'all what the number is. All right, so it was Wisconsin law 293.04 and 295.19 is what they were charging him with for trial. The judge made a distinction that for probable cause, they used another statute, but 94, so it was 948.60, which is the statute they use for to find probable cause and indict him. But that wasn't the charges that they ultimately brought before the jury to make a decision on. Rittenhouse is going to get off. Okay, at this point, he could get off, which is what we're all expecting, but there could be a break, there could be an anomaly, and he doesn't. Okay, so the reasons why, when you look at the statutes, right? First, second, and third degree, everywhere you go, any state you go to, has different wording to it that makes it first degree, second degree, or third degree. One has to do with involuntary, one has to do with intentional murder, and then one has another language. So they have three different languages. So when you look at what you can charge somebody with, it's based on if you can prove that the person did that intentionally, or they did that or they did something involuntarily, or you know, so it all depends on how the law is written and how you can prove your case to it. The fact it did is shit. There's no way possible that charges can be thrown. Yes, charges can be thrown out. You, the prosecutor, has to meet the burden in every element of a charge. If you charge somebody and then you rest your case, but you haven't provided evidence of all, you haven't met your burden on all the counts in that charge, the judge could throw it out. The judge is not going to be up there in the middle of your case. You're the prosecutor saying, hey, include this. Y'all remember Law and Order? Y'all remember Law and Order? There was the head prosecutor, right? McCoy. He went to Adam Schiff. What do you think Adam Schiff's job was? Adam Schiff's job was to look over on a daily basis what McCoy was presenting out there and make sure he met all the elements of his charge. They couldn't even explain the elements of their charge to the judge. The fat dude, Cross, he was just like, Your Honor, just let it go through. No, that's not how you make an argument to the judge. Even if the judge is hostile to you, you do what the one that looks like Tom Cruise do. You argue your motherfucking point. Fatty sat there and was like, I guess so, Your Honor. You know, whatever. Just let it in. He did what fat people do. I'm sorry, I'm in my fat people moment. He just gave up. He just wanted a Snicker bar or something. It was like just fucking annoying to me. I was so frustrated with the prosecutors because I felt like they was just too beat up, or they allowed themselves to be too beat up, or just, and I'm sorry to say this, as prosecutors, you don't get to pick. You represent the state. Sometimes you have to put on a case for a very bad guy. But if your state doesn't allow for murder, then you have to represent that person that was murdered, even if that person is a very bad guy. Just like defense attorneys have to defend people who are really bad people, because the law provides that they have a right to a fair trial and to be represented zealously, not with lies, but zealously. So that's just crazy. Okay, what were the pluses for the defense? The pluses for the defense, first and foremost, is that they had a judge that was on their side. A judge that was very cautious and erred on the side of the defendant a lot. But unfortunately, most judges do that same thing, except in black trials. There was nothing that said self-defense in that case. He went there with the intentions to kill. This is what I will say to you, Jola. He went there with the intentions to protect property. And that is what they proved to be the most. Oh, meant to tell y'all, good point I've been missing. So stop, let me get this out. The brothers, right, that own the lot, very interesting thing. They removed, after the first night and then one of their shops got hit with cars being smashed and burnt, or they removed most of their inventory that they could get out of there for it not to be destroyed. So there was no need in some of those facilities for it to be protected. They didn't need protection. Thought that was an interesting point made by the prosecutor when he said he brought them forward, even though he thought they might lie. I thought the defense did a great job giving you their highlights of what their takeaways, how each person that testified worked on their behalf. And I believe that this was evident, that the prosecutor did a terrible job, direct examination or cross-examination of the witnesses that the defense presented. And they gave you every win they thought they got from every person that testified. And what does that do? That helps develop reasonable doubt in a juror's mind, because that's all you need. You just need one instance of doubt. So if you can find one thing in each witness that the prosecutor puts up to say, this is why you should doubt that, and this is the reason why you should doubt that. And that's that. So now, they tried to paint a picture that Rosenbaum, which is the first person murdered, was not released from the hospital, but was released from the jail hospital, which I found to be very interesting, because they basically said, the prosecutor basically said, he was released from a hospital and was specifying a hospital. But the defense came back and said clearly, I don't give a damn if it was a hospital or the jail hospital. He still was just released from somewhere. So that was interesting. And their position was that he was released from the jail hospital because that bag he was toting around as if it had his last valuables ever came from a jail, was a jail. Everybody could recognize it as a jail bag. One of it said so-and-so correctional facility, but the bag was never redeemed. It was a plastic bag. But the prosecutor at the end of their closing arguments also showed footage of this dude getting pushed around, right? Because Rosenbaum was some little shorty from the 40s. He was a little shorty being pushed around. And he said, yo, look at homie. He's being pushed around and this and that and other thing. Some big dude pushed him back, right? He said, but look at him. He goes back and says to the dudes that just finished pushing him, telling him to go, can I go over there and get my bag? Yeah, that shit had me laughing. So he was like, so he went back to get whatever was in that little bag. He said, my bag is over there. Can I go get my bag? And they let him through to go get his bag. So this is supposed to be like a real touchy, you know, irate situation going on over there. And at the end, he's like, can I go over there and get my bag? After they done pushed his ass around that. He didn't protect anyone or anything. So that protection claim is hogwash. Oh, okay. You can't. Okay. I hear your argument, Jola. I'm going to keep it strictly to this case and what we heard in this case in a comparison to another case. When we get to the decision, then we can do the comparisons to jurors and stuff like that in those cases. I prefer to just have the discussion based on what we hear here and the contrast between the prosecutor's case and the defense's case based on just that. Let's see what Gear says. What evidence was not provided that Carl was not in possession of a dangerous weapon? What evidence was not provided? Gears. You have to go back to this case. These laws that they was looking at, the 293.04 and the 295.19. The language in there only goes up to age 16. It has nothing written in the law that's applicable to age 17. That's where the problem came in. And it was hunting, had something to do with hunting licenses and stuff like that. And I wish we had more time to discuss that as a collective. So that's a good question, but it is what the law they were citing that he violated, that they did not prove all the elements of it. And the defense wrote they made a motion to dismiss it based on the fact that Carl was 17 at the time of the crime, and everything written in the statutes that they were bringing against him were for 16 and younger. Nothing covered him being 18. So we, in our conversation on Friday, felt as if they were talking about the wrong statute, or that the prosecutor used the wrong statute. And yesterday morning, the judge elaborated and said one of the statutes was good enough for probable cause, but the other statute is what they use. So it's what law they used that they couldn't prove. They didn't meet the elements. He was over the age of 16. Everything that was written in that statute was for the age of 16 and younger. Nothing covered 17 and up, even though they have a state. So the bottom line, people will walk away from that state understanding that any child over the age of 16 can have a gun. If you're over the age of 16, you can have a gun. But if you're 16 or younger, you should not have a gun. Even though there's a statement that there's a law that says you cannot have a gun, possess a gun under the age of 18, but it has nothing else, no meat and potato to it. What's not true, Gears? I'm only telling you what we had before us as the discussion, what I heard in the discussion. I'm not saying that you cannot have a gun at the age of 16. You can have a gun at the age of 16 with these conditions. they could not consider that law in respect to Rittenhouse because he was 17 at the time. And the law is written in respect to 16-year-olds. I'm not saying that 16-year-olds cannot have a gun in that state. They have provisions in there that are about having a gun at 16. They have it from 14 to 15, I think, and then 15 to 16. But you can go and look at the law itself. Is 293.04 and 295.19 that they was referring to, that speaks on ages 14 to 16 and whatever. I don't have time to do it now because I'm supposed to be at work. Why was this decided at the end of the trial? So Amber, at the prosecution shouldn't rest unless they meet all their elements. Normally, a prosecutor has the elements of their case. So when I do things in my professional life, we look at the law, we write out the whole law. And if the law has an A, B, or C, right, we put it in a spreadsheet. This is the law. And then in the other columns, we write down how we're gonna meet that requirement of the law. You can do it on a regular sheet of paper. You have to meet each element of that law. And we go through it to make sure that we put out evidence to support that law, that element of the law that we're looking at. And it's piece by piece. In this case, they had their 6 charges. You will hear them arguing with the judge. Yes, I elicit testimony that supported this, and that was in relations to this this element. That's what you see most attorneys do, where they'll say, we met our burden. If you're watching them on the stand, you see them circle things, you'll see them check off things in their list because they are checking off the stuff, or they have their own way of coding their responses to say, boom, I met that burden. I took on, like, I need to make sure that this person is 16 years old, over 16. They have it written out. They didn't do that in this case. They really didn't do that. So at the end of the case, when the prosecution rests, so first the prosecution rests, then the defense rests, then the prosecution gets the rebuttal. After the prosecutors close down rebuttal, you look at the charges and you say to yourself, has the prosecutor met their burden? And that's why the charges could be thrown out. If you notice, somewhere in the middle of the trial, they threw out the charge of being out past the curfew. It's obvious they had to throw that out. All of these people that testify were all out past the curfew, violating the curfew. Every time somebody got up there, the prosecutor could have said, the defense could have said, hey, are you being charged for being out there after curfew? So it becomes biased to their client that he's the only one being charged with this. But here you got guy with the missing arm. He's not being charged with this. Here you got the guy that was his friend with the gun. He's not being charged with this. Here you got the guy that took the pictures. That was there. That was the reporter. He's not being charged with lawfully disobeying that order. So yeah, you can't just say, I'm going to charge Rittenhouse with this, but everybody else that was there that night that comes up and testify, we're not going to charge them for the curfew. Oh no, they got a free pass because they testified against them. That would look like a bias. So it was best they get rid of that, because they would have had to prove it in all of these people cases. And then all of these people would have said, I have to plead the fifth because I'm going to be by pleading here, by saying here that I broke curfew, I'm admitting that I broke that law, and by breaking that law, I could be charged with it. So that's why that got thrown out. And that's the rationale behind it, just to show you why things why charges are dropped in the middle of the case. They can't make their case on it. That's just it. And it's a bad move to have shit thrown out because it messes with their credibility. Because even though you tell a juror to ignore something, you don't really know if they ignored it. So I thought that they did a good job, the defense, and breaking down good points for each of the people. I think they lost a big point when they put that police officer on there. I didn't like a little snooty ass attitude, but there was a police officer called to testify about picking up gun casings and what she picked up and logged in, because they were trying to prove, the defense was trying to prove that there was no reload because there was no new bullet on the floor, one that wasn't used or whatever. So when the guy said he re-racked, the defense was proving that he couldn't have re-racked because there was not a new bullet on the floor, an unspent bullet, one that wasn't done, right? But their own witness, under cross-examination by the prosecutor, said that in those kind of guns that he had, it may appear to be a re-rack situation if the casing from the previous round got stuck inside the chamber or something, then didn't disperse. So you would have to re-rack or use the motion of re-racking to clear that out of the chamber or wherever the hell it was at. I am not a gun person, so this is what my take on what I thought I heard. That was it. I don't know how many of these jurors are gun people, but shit, the way this whole city was sounding, it sounded like everybody got a goddamn gun, if you ask me. They tried to make a connection between these professional protesters / rioters being just there for trouble and Rittenhouse being there as a model citizen, only being there to help. Lesson to everybody, don't help. You could be sitting on trial for shit like this. They remind people that although they put on a case and they put their witness up there, their witness was put up there, but the burden of proof is still on the prosecutor. And they just wanted to lay out the things that they don't believe the prosecutor meant. Their theme was that this was a rush to judgment, and after the prosecutor arrested him, they just had to keep going through with it. He put up an issue that the other people were not, the guy who fired shots in the air, they were not called. These people that were vandalizing property and burning shit down, they were not called. The prosecutor says we didn't call them because we're going to charge them. They got an open case next month that's going forward for vandalizing. And the prosecutor said in his closing argument, had Rittenhouse not killed these people, or at least Rosenbaum, I could have tried him for the crimes he committed that evening. But one thing that no matter what they was doing out there, burning shit down, whatever, he did not deserve a death sentence. Daunting words for me to hear, because I agree with that statement. No one gets the right to decide who lives or who dies, especially in a situation like this or the situation that he was in. And the prosecutor points out that Kyle Rittenhouse had an opportunity to continue to get away. He stopped and shot that man. That was intentional. That was not self-defense. He turned around and he shot that man. And it wasn't because he was afraid to go anywhere else or couldn't go through anything else, because he definitely went through. What pisses me off is that they did not point out that he took a fucking victory lap, because he went around the car and looked at the person after he done shot him 4 times. He didn't offer him anything, because that looks like a skip and a jump to me that he did. But that's just my image of what I saw, how my eyes looked at it when he shot the first dude. Because he looked like he did a victory fucking lap. And if you look at how he's running, okay, like a little snake or like a little weasel. I was like, boy, bye. Okay. I wanted to, okay. Something else hit my head about something about search warrants. They was just the defense was just arrogant with their disdain for the witnesses in this case and the whole notion that anybody could think otherwise about Rittenhouse defending himself. That was just a real arrogance. But we'll see how it comes off to the jury. I just think it's amazing that they don't have, with all of this footage from that evening, they don't have not one time the man he shot that he said was making threatening comments that they have it on tape, that they have any footage of it. And last but not least for me, it's even that the man himself, at the time he was being shot, did not have a weapon front facing him. You have to kill somebody with equal, the threat has to be equal to each other. A plastic bag in your hands to an AR-15 is not comparable. So I don't, first count, I don't believe that it was self-defense. I'm having an issue understanding the reporter dude. Did he recklessly endanger the reporter's life? If I was the 13th juror, I would have to say yes, because he intentionally killed the first dude and his bullets was going all over the fucking place, and it could have hit the reporter, even though the reporter's story did not line up with the video that I saw. I did not see the reporter hugging the building, as he says. I saw the reporter standing in the middle of the fucking shit. So I don't know about that too much. The third person that he shot and killed, that he shot and killed was the Anthony Hoover dude who was on the who hit him with the skateboard. So we're supposed to believe that the skateboard was as dangerous a weapon. Having now viewed why he was being chased by Huber, which is coming from the opposite direction, and just hearing stop that man and engaging in that activity of stop that man, seems to me that he wasn't killing him in self-defense, because he got hit in the head with a fucking skateboard. But could a skateboard be a deadly weapon? Could that man have had the right to hit him with the skateboard? Absolutely. He just finished seeing him shoot this other motherfucker over there, and he was up on him. So I guess you would try to subdue the victim. If he had lived, he could have told us what his intentions were. So I don't believe that one was self-defense either. It could probably get one of the, but see, the lesser charges is only if you believe it was in self-defense. So I was all confused with those, but I probably would have to say that the second kill, again, to me, was not self-defense. Now, the third shot, the third victim there, the gross crust is the only one I probably would say would have probably been self-defense on both angles. because the man had a gun face. The man had a gun. They try to marginalize or minimize the effect of that gun that he had in his hand, but there was really none for me. He had a gun on him. He could have shot him if he wanted to. And technically, if he hadn't have froze up like a punk, he probably would have shot him. Now, was his gun anything like when the guy went to reload, he should have took his shot. He should have took his best shot. But like he said, he didn't want to kill people. Then you shouldn't have been there with the gun, and you shouldn't have had it out. And on top of it, he didn't lawfully have a right to carry it at the time his permit was expired. Blah 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 blah. So I just have to be like, whatever. But that one, I don't know. It could be the only one that's self-defense in my eyes. I never seen some of the arrogance in this matter is what you see when you have the privilege. And I find it funny that they're calling your Fifth Amendment, your Second Amendment right to carry as the privilege. But that's about it. Those are my thoughts on it. I'll see what the jurors will get it today. What they will do is randomly select 12 of them to actually serve. I believe it's 16 who are seated. 12 will serve, 4 will sit in the background just in case, it gets into a heated fight inside there and they have to replace somebody or something holds up. They'll have 4 alternate jurors still on site to do this. I don't know if anybody in this case, if I would call anybody in this case a hero, but I will just say that if you're going to protest, be mindful of these professional protesters, because this is the shit they're engaging in, stuff that could get you killed for being out there exercising your right to assemble. People got all kinds of shit going on with them. I wonder if any of the victims' families were present for this trial. They probably have been, because remember, these guys that were shot and killed are from the Jewish persuasion. So their families are present. But they only become a focal point if and when there's a guilty verdict. Then they get to tell you their impact. The reason why, in contrast, the Ahmaud Arbery situation, you seeing the parents there is because those prejudiced ass people over there want to make a big deal that Ahmaud Arbery has family in the courtroom. That's my take on stuff. I know it's been long overdue on the case. Again, I tried to give you the perspective from both listening to the prosecutor, listening to the defense's argument. So I want to thank you for participating today so openly, and let's see what the verdict brings. We'll be back when we'll be on verdict watch now, and we'll be back after the verdict to discuss what's happening there. This is Mo, and I've got to go.